Bună dimineața tuturor!
Good morning, everyone. I think we shall begin. I'm Tatiana Puiu, and I represent the international organization Freedom House in the country. And I would like to greet you at the event Transparency in the Decision-Making Process, Expectations and Realities. So before starting, I would like to mention that we are having the event on the Zoom platform. There will be simultaneous interpretation mentioned, so you can choose your channel via the interpretation globe. This could be also watched on the social media. If you would like to take the floor, write a message in the chat. So the consultative process in the parliament would be the main topic of discussion today with the experts, civil society experts in the Republic of Moldova. In particular, we shall debate the risks of adapting laws in a rapid process, the gaps of the public consultation and the parliament, but also solutions for enhancing transparency of the lawmaking process. I would also like to mention that yesterday we launched also the report Access to Information Index, the transparency of the institutions of the Republic of Moldova. So the report actually includes a comprehensive assessment of the transparency in the Republic of Moldova as a result of the analysis of the regulatory framework and the practices of a sample of over 50 public institutions. And we have noted that the general level of transparency of the public institutions in Moldova is quite limited, and the results of the report are alarming because they actually show gaps and in all the aspects of the transparency of the Republic of Moldova, and there's transparency only in the only within some institutions. So we shall post the link to this report here in the Zoom platform. And those of you that follow us on the social media, please access the report on the official website of the international organization Freedom House. And another important clarification is that this event is organized within the framework of the Citizens Speak And having said this, I would like to offer the floor to the chairperson of Preventing Corruption, Galina Bostan, that will moderate the session on the decision-making process and consultation process in the parliament. And then Natalia Roshka and Ms. Chaban will take the floor. Galina, you have the floor. Well, of course, today's topic, it needs to be mentioned, is important. Otherwise, this topic of the transparency of the decision-making process invariably, or regardless of the governance, has had quite a big share as many times as the representatives of the civil society express their opinions with regard to various norms and decisions, administrative decisions. So the problems are the same. However, things need to be discussed in any case, and we need to identify solutions. Before moving to the discussions on the topic related to the transparency of the decision-making process within the parliament, and taking into account the fact that among those that are following us, there are people who not necessarily know the details of the law on the decision-making process transparency, I would like to highlight the main elements of the law, which are of interest to the public, and answer the questions who, what, and how. First of all, the law on the transparency and actually all all the local authorities, central authorities, and subject of this law are legal entities, both public and private, which manage public financial means. As regards the laws which are subject of the provisions of the transparency and decision-making, normative acts and administrative acts, which may have environmental, economic, and social impact. And the third question of how, well, we can answer this question in the main phases of transparency ensuring. And according to the law, there are 4 stages. So the first one includes the information of the public on the initiation of the drafting of the decision. And this is mainly about publishing an announcement on the initiative to draft a decision. And this announcement has to be published in 15 working days after the initiation of the decision-making process. The second phase is to provide the stakeholders with the draft decision and conduct consultations. At this stage, the authority shall ensure access to the materials. So the announcement and the materials are announced at least 15 days before the draft decision is finalized. And the third decision would be to receive and review the recommendations of the stakeholders. And this stage implies that there is a possibility to present these recommendations and the presentation of the recommendations can be made in 10 days. And this timeline can be extended upon the request of the stakeholders. So the recommendations can be both verbal and in writing. If they are provided verbally, then they would be reflected in the protocol. The recommendations are analyzed by the authority responsible for the draft decision and can speak of approving or rejecting each proposal in part. And this is done in a synthesis, as a table. And finally, the last stage, which results from this entire public consultation process, is the information of the public on the decision which had been taken. And we have revised now all the phases, all the stages, just to, well, to understand very well how important it is to respect all the stages and effectively respect them. So before offering the floor to the panelist, Viorel Parvan, I would like to draw your attention to the fact that you can ask questions in the chat. And secondly, I would like to ensure that there is interpretation provided. So Mr. Parvan, you have the floor.
Bună dimineața tuturor!
Good morning, everyone. I would like to share the screen with a small presentation. I hope you can see my screen. So our main topic today is transparency, decision-making transparency. We shall look at this topic both separately as well as through the I will present the situation with the project which has looked at the legal framework, and this is about the declaration of property and personal interests, and that was included in this. And here I would explain the whole process of consultation. So this draft that is an amendment draft, had been registered at the Parliament on the 4th of August of this year. After 8 days, it is already reviewed in the specialized commission, and on August 13, after 9 days, it is passed in first reading. So, speaking of the requirements, which Galina also referred to in the very beginning, we can see that we were quite rushing into, I mean, there was quite a haste in the process, and the Commission indeed organized public consultations on the 19th of August after the approval of this draft law in the first reading. So the consultations were attended by a number of stakeholders, civil society organizations, the public institutions, and ANI. Well, the discussions were good, but they were kind of general conceptual discussions, and it had been agreed to make a change. So, and the most of the participants made a range of recommendations to improve the draft. So it was promised to have one more round of consultations and discussions. Unfortunately, that didn't materialize. So the Commission finalized the draft law. It has been turned into a new draft law. The text had been essentially changed, and this new text of the law had been revised by the Commission on the 7th October, and the same day it had been approved in the second reading. So that was the story of the draft law on amending the law on the declaration of personal interests and ownership of property. So the purpose of the law is really noble. I mean, what the lawmaker wanted to do was necessary. It was necessary to improve the legal framework and to find solutions to the existing problems, serious problems, which refer to this process of declaring and checking the property, the ownership of the subjects of the declaration, and to guarantee the functionality of the NAI and the integrity officers and inspectors. However, we believe that, and also other representatives also believe that, including public authorities, and that there were some questions, quite natural questions, because the text is important, and this has a lot of provisions and norms and concepts, innovative concepts for us, for our country, at least for everything which had been done so far. And therefore, we had some questions whether these norms would address the issues in the system. So if these norms would create more difficulties, certain legal uncertainties, if these norms would help any address issues, or they would lead actually to more blockages. There were also questions whether these norms would impose certain burdensome requirements and would lead to the violation of their rights and freedoms of these third parties. So all these natural questions should have been discussed. There should have been solutions found already at the consultation process that we are dealing with today. So we have made 15 recommendations, and we have checked. 4 have been accepted, 1 was partially accepted, and 10 were rejected. So, and I think that those 10 actually represent those huge questions or unclarities for which we still didn't find an answer. So if we were to look at the proposals which were accepted, and including the anonymous information and the rights of the person to notify the contradictions anonymously. So the proposal to exclude the norm which granted the possibility to suspend from positions persons in relation to which there was it was found that they have violated the legal regime of declaring their property and personal interest, because that could, in a way, extend the process or delay the process. So I'm not sure whether there was a final outcome reached there. There was also the proposal accepted to keep the procedures to check the candidates for the positions of chairperson and deputy chairperson of the National Integrity Authority, the testing with the polygraph, and also they have accepted proposal which referred to the very vague formulations which may lead to interpretations and abuses. The so-called formulations such as using such interpretable phrases as poor management as a reason to seize the mandate of a chairperson of the NAI. So if we were to revise the provisions which were not accepted, and they were the problems identified by those which participated at these consultations. So we shall begin with the obligation for third persons which are not subjects of the declaration, which are checked or inspected by ANI, or the draft provides for the new amendments actually provides that these competences of ANI will influence not only those which have the obligation to declare their property, but also third parties, members of the families, persons which donated money, or any other third person. So the purpose of these norms as such can be understood, and this is done to exclude the cases which happen more and more often, cases of avoiding the punishment or being left out of the control and punishment if there are cases or such cases. However, the manner in which it had been included in the text of the law from the very beginning raises our concerns. And the most important thing is whether there is a risk to admit certain abuses in this regard without the clear provisions of how this process is carried out, this control and inspection in relation to third parties. So these new amendments read that as a new instrument to assess the property of the persons. So first of all, there is this possibility to check this information both by the integrity inspectors or by somebody else, but there's no specification who else. So it is vaguely it vaguely reads that the inspector can assess these without providing for specific cases when this could be done and when not. And this can lead to certain interpretation risks, or this may lead to discretionary application. And there is this mention that the inspector would do this on its own, and it is that the inspectors can do the inspection of the cadastral aspects and all the other real estate and so on. So the inspector will be doing that, but we don't know how such a form could be implemented in practice by the inspector and whether the inspector would implement it correctly. Also, the amendments which have been made have not provided for financial sources. They have provided only for the possibility and the right to make these assessments also by other persons, probably certified as evaluators, but there were no funds provided for that or a legal base, a law, so that this law would provide for financial resources from the budget for other persons to do these evaluations. So there is another law which had been already approved, which impose, well, or lead to certain doubts and uncertainties, and this is about the provision of the right to the integrity inspector to provide assurance measures with regard to the unjustified property. So this insurance measures at the moment is provided for only within the processes where the court can rule these measures or the bailiff can rule these measures with certain procedures, like certain acts are issued, the right to challenge this and so on. But in the example, and the law 132 of 2016 provides only for the right that insurance measures can be applied without giving details of how this process is carried out, what kind of measures can apply, and so on. A moment which we have identified was that in the law, there was the submission to grant the possibility to challenge the protocol for refusing the initiation of the control. So a person can challenge, ultimately can challenge the act when there is where there is an inspection. But if the integrity inspector refuses to initiate the control, there's no mechanism to challenge this refusal and get
Și un
and to
ultim
revise this refusal decision. And another quite important aspect, probably the most important aspect, which actually has led to a number of issues, was to declare the real value or the market value of the assets. Well, we believe that yes, these things should be clarified. That's true. The situation cannot continue as it used to be in the past, but this should not be made in a way when we would not be able to apply this in practice, or both the civil society as well as the ANI has certain reserves and does not know how this instrument would apply in reality. The instrument of declaring the real value, and when there are big gaps between the real declared value and the real market value, which would be the sanctions. And so there are quite many questions to which the law does not give an answer. And that answer should have been provided in public consultations with all the stakeholders. As our today's topic refers to transparency, transparency is something more complex. Transparency as such does not represent only the publication of a draft law on the website of the parliament and sometimes even discussions. This is not really only transparency, because transparency is engagement, discussion, dialogue, finding solutions, so that in the end we have a good law, and those which apply it know how to apply it. The law, those to whom the law refers should know what obligations they have, what behavior they need to take in order to apply the provisions of the law. I tried to make a little exercise to look at the draft laws which had been submitted to the parliament, registered in the parliament, starting the 1st of September until the 30th of November, and see at least the manner in which these had been approved and finally approved, if there was a rush and if there are any violations of transparency requirements. So what we have identified was that out of 106 draft laws registered in the parliament in these 3 months, the most were put forward by the members of parliament, 70, government 23, and the president's office 13. So far 63 had not been reviewed, 43 had been approved in the first reading, and 37 had been approved in the second reading. So in the first reading, out of the 43 draft laws, 74% had been approved in a timeline between 1 and 15 days, out of which 44% had been approved in less than 7 days. So less than a week after their registration, there had been already approved in the first reading. And well, 1/3 of them had been the legal initiatives put forward by the MPs. Here, I would really like to see whether we really need to rush like this, and if there is a need to rush into reviewing, analyzing the proposals of the members of parliament, making such deviations from transparency requirements. Therefore, 7% were the draft laws approved in the first reading in the course of 15 to 30 days, and 19% were the ones that were approved in over 30 days from the moment of their registration. So if we speak about their approval in the second reading, if we look at the 115 days from the registration of the project, 32% of the initiatives had been already passed in the second reading. So 1/4 of these proposals or these draft laws were put forward by the MPs. So these are just some figures which would help us understand, at least understand the phenomenon, and make us understand what is happening, and if there are deviations from transparency decisions. And this would probably a point of discussion at the next session. And my colleague Natalia Roshka will present her part of the session. So thank you for your attention. Natalia, you have the floor. Well, thank you very much for this exhaustive presentation on the experience of our experience of effectively applying the provisions of the law on decision-making transparency. And thank you also for the calculations of the statistic data, which had been realized on the basis of information from the website of the Parliament. And as regards the impact of the statistic data, we shall discuss that in the following session. However, until then, I would like to offer the floor to Natalia Roshka, who will tell us about a different experience of implementing the decision-making transparency law. And this is the opinion CTC on another law of enhanced public interest. So Natalia, please, you have the floor.
Bună ziua tuturor. Sunt Natalia Roșca.
Good morning, everyone. My name is Natalia Roshka. So the opinion of the CAPC 180, 181, these are the initiatives that that had been reviewed. So you can see the presentation, I hope. I shared my screen. So these are draft laws on amending the law number 3 of 2016 on the prosecution service. And the proposals were draft laws were 180, 181. So I don't think I should provide the opinion of the CAPC because it had been described when we have presented it. And today we shall not discuss the contents of this and I will shortly present the opinion of the CIPC, and I will review the opinion of the CIPC and how it had been seen. So in general,
Obiecțiile CAPC-ului au fost de două tipuri. Au fost obiecții de tehnică legislativă și tehnică și proces legislativ și obiecții conceptuale. Noi am făcut obiecții de tehnică legislativă pentru
so we had two parts.
They had regulated sometimes. Okay, look, creation of the Superior Council of Prosecutors. They had norms that mood norms that are already found in the current law. So it was necessary for these drafts to be improved and to be tailored both from the legal technique as well as conceptually to the existing law, so that the amendments proposed would comply very well with the current law and be very well framed, so that we don't end up in a situation, classic situation. So in this regard was the reason to fire the Prosecutor General by disciplinary sanction. But before these amendments, the law on prosecution already contain such a reason to fire the Prosecutor General, and today we're in a situation where the law, this article, contains two norms referring to the same subject. Now, the legal technical objections were about some aspects overlapping norms, operation with different terminology, and here we mean the qualifiers that have been offered for the assessment of the Prosecutor General and scattered regulation regarding the same object of regulation, where we refer to article about the creation of the Superior Council of Prosecutors, where you frame some additional norms in between Part 1 and Part 4 from the point of view of legal technique for better understanding of the norm and for good and clear application of these norms. It would be good for them to be tailored and concentrated in terms of content. Now, conceptual objections were the most important and the most severe ones. So if we are to be presented concisely, in the opinion of the author that formulated those, so through certain provisions, there was a distortion of the concept of the Superior Council of Prosecutors as a self-managing body of prosecutor. There was the politicization of institution, both institutionally as well as processes which are in the institution. I mean, the prosecutor as a big institution, and they were favoring a certain political actor in certain stages when it talk about Prosecutor General, and they've introduced the arbitration in the activity of the assessment and sanctioning of the Prosecutor General. I think this arbitration, so arbitrary decisions, this is the most severe problem, because it actually violates the principle of predictability of legal norms, security of legal norms, principles without which a rule of law country cannot exist. I mean, we cannot sanction, and by the way, these norms, the creation of the arbitrary decisions is against all standards of the community standards that we try to align to. Now, it is very good, and we should regulate. I mean, look, the normative solutions should be with multiple application very clear when they applied, and for which situation, if you do an assessment for which criteria this is done. And as a final conclusion of these norms, we believe that the creation of normative solutions happened because of the exceptional situation. I mean, one did not deny the exceptional situation that we have today in the prosecution. It is not the topic of today. And one wanted, and there had to be some normative solutions in this regard, but they had to be aligned to the regulatory requirements, because there's nothing more dangerous than norms which are, I mean, than just you know, unclear norms. So it means that the future composition of the parliament and the future generations, because it means that they could do it, then I could do it as well. So that is the most severe, to the detriment of the clear norms of regulation. Now, legal procedure aspects versus decision-making transparency. This is today's topic. On the webpage of the Parliament, you have, I mean, look, I've had data from the Parliament page. Look, I've listed them here, and it's quite representative. And one can see and understand clearly things, because we don't have here, you know, full compliance with decision-making transparency as per the law. When I say not quite, I mean almost at all. Unfortunately, we had some public consultations on August 18, and they haven't even been reflected on the webpage of the Parliament. Now, what I've noticed, at least when it comes to these two laws, there is no table of reconciliation, of comparisons. There was no, they haven't even put the proposals that came from the civil society to these draft laws. And if you look at the documents that have official documents that are posted on the webpage of the Parliament, the opinions of the commissions and of the authorities, I mean, we can see that the opinion of the government comes after the adoption of, in the first reading, or hearing, sorry, and then the anti-corruption review comes after the opinion of the government and after adoption of the in the first reading, but adoption in the first reading of the drafts. Well, that says otherwise. So the amendments that should come after the first reading adoption should be non-essential, should be they shouldn't change the essence and the logic of the draft. Now, so that this doesn't happen, one has to comply with the decision-making transparency at the first stage. So the announcement about the initiation of the draft, and one should work a lot at the stage of public consultation and opinions. Now, these are some conclusions that I present on the topic of decision-making transparency and our opinion regarding these two drafts. Now, as I told you about the opinion and about the opinion of the NAC. We don't know who presented opinions from civil society. They're not reflected anywhere. We presented opinions. We don't know their fate and why they haven't been examined. So, I mean, we could have a there could be a problem because they haven't been examined. And having the experience of the work in the process of developing normative documents, but given our normative framework, nowhere it is mentioned that the author of a normative document should accept or not accept an opinion received, actually. But we have to say that this opinion must be reflected and must be reflected the opinion of the author with regard to this proposal. Proposal that comes forward. What was the rationale of non-accepting it? We're talking about normative documents. We're not talking about commercial processes that are covered by secrecy, commercial secrecy or other secrets. We're talking about a process that has to be totally transparent, except for the documents which are covered by the state secret. And if we refer to the these two draft laws haven't been submitted to the Venice Commission and to the European Council, sorry, the Council of European Judges, or Council of Europe at least. We as a country, when we have developed and approved the law on prosecution, One of the conditionalities that have been submitted to the put to Moldova was to receive the acceptance of the Venice Commission. Now the draft has been submitted and cleared by the Venice Commission twice. Now, when we make changes, conceptual changes, which actually really politicize the system in a bigger way than the old law, and probably it would have been necessary, including in the framework of the association agreement and responsibilities and international obligations that we committed to request the opinion of the Venice Commission. Now that is our opinion. So that is all about the transparency. The worst in this is that nowhere do you find and nowhere do you have the opinions. And actually, it looks like this lack of consideration when it comes to any other external opinions or opinion of the civil society to these draft laws, which actually is sad. That's sad. That's all. Thank you very much for the presentation. I just wanted to reiterate this one idea that decision-making transparency is one of the key tools to increase the transparency, performance, and confidence of citizens in the public sector. Now, I understand, of course, I understand politicians, parliamentarians, probably hear how political processes are so intense that sometimes it is even concerning when representatives of NGOs or experts they come forward with opinions and criticize, and then others are not okay with this. Well, the whole purpose of decision-making transparency is to improve the quality of normative documents, and we do need this improvement of normative documents. The fact that we change so much the laws, so many times, a law is approved and then you have changes to it shortly after the approval. And what is important is that what is weird is that the fact that you introduce changes, this is an indicator of the bad job done by them. This is not an indicator of the fact that they work a lot. This is an indicator of a job badly done. That is why this permanent change of the rules of the game, which comes from one parliament to another and it endures from one parliament to another, actually that drives away people from this country. Maybe some people don't need this help of the state, but they need stability, at least legal stability, that those from the parliament could ensure. Now, so the fact that you don't apply the law on decision-making transparency looks like this is something simple, but because it is not implemented effectively, it actually affects the quality of the legal process and the quality of the laws. I'll just make one comment so you should add one more thing, that the law was published in 28 October 2021, a month after it was voted in the second reading. Now, to criticize a lot, we don't need to do it. I've spoke about it before at a different meeting, as well as talk to the different partners in letters and information that I gave out. It is necessary that when you change the law, you should invite the institution, the authority that will apply the law, so that then you would have the question, who is responsible for the failures for which you cannot apply the law? I mean, the risks that Mr. Pervan presented, that you have bureaucracy, red tape, or work there's misalignments. Now, what we wanted as an authority to be heard, actually, well, we didn't have the recommendations, proposals presented by the civil society to the technical document from the developer partners, to the World Bank, Council of Europe, which came with two important proposals, efficient proposals that would not destabilize and that would not stop certain working processes. Anyway, this was not taken into account. What we wanted is that in the final and transitional provisions to have certain remarks or caveats. So what will be the finality and what will be the applicability of the cases that we studied? And we should not forget one more aspect that so we have electronic process of submitting personal incomes and interest. It is necessary to identify TOR, to make public government identify who is going to be the developer. Even though we have the law and government decree that tells us who is the developer, now we have the refusal of the cybersecurity service, and that will take time. Now, once we make public the law, it becomes effective immediately, and then the authority should, first of all, come with training and awareness about how you declare personal incomes and interests. How will you declare the assets and virtual incomes? What is going to be the procedure of control of the cases about the income when you have third parties? So all of this must be explained by the authority, even though we have an opinion from the legal committee, so that they could at least guide us and to be as close as possible to the subject of declaration. The importance of changing the legal framework of the National Executive Authority, as it was mentioned by Ms. Rushka, this was a conditionality in 2016 with certain requirements from the EU and other partners for Moldova. Now, we, those from the authority, we don't want to blame this topic, but we want to be as close as possible to the subjects of declaration, especially when they cannot harness they cannot declare houses or cars, because when you change the law on declaration of public interests and incomes, when you can declare the asset at the market value, it doesn't mean that we solve the problem. This problem requires for the state to take into account that when you sell an asset, regardless whether this is a car or a house or it's a simple furniture, the state must have a correct transaction signed between buyer and seller. It has to be in the interest of the state tax service to tax the amount which is in this contract. And also there has to be a rule regarding the buy-sell contracts of cars, which you have fictitious contracts, and we've identified this while doing the control procedures done by the decree inspectors. The rule is not done by us only, but what we proposed in 2019 until now, we proposed to make changes to the civil code, tax code, to involve the tax service, Ministry of Finance, and many other authorities, so that the subject of declaration, the person who comes to the public service or is a dignitary, to be well informed, to have the necessary documents, so that later on he is not part of various journalist investigations or cases which will be into his judgment. So the purpose of our authority as a mission is, first of all, to educate public servants or how they should declare interest and personal incomes, or how they should solve their conflicts of interest and incompatibilities. And when these lessons are not learned or they're not taken into account, of course, you have the control procedures that are conducted by the integrity inspectors. Well, I believe that these changes will appear as risks that we, of course, about which we should inform the society and which will be presented in our activity reports. I mean, you'll be noticing that in the next quarter of this year, when it comes to the activity of our authority, you will notice a difference in the process of initiation and refusal of cases that we conduct. And of course, we will have the proceedings in the court, and we will not be able to optimize the working process of the authority. But the time will show. And what we want to succeed in is to have, in general, first, a form available for all subjects of declaration for them to declare their personal incomes and interests, and to inform the subjects of how they will submit the declarations starting with 2022, and then we'll come with analysis and results that we wanted. Thank you. Thank you, Ms. Antic. Just wanted to give the floor to colleagues from the prosecution. Dumitru Opara, because one of the subjects tackled in this case study were the normative documents regarding the activity of prosecution. Mr. Opara, you have the floor. Thank you. Colleagues, hi. I am Dumitru Obado. I'm currently head of section in Prosecutor General Office. Let me thank you for the initiative to focus on the issue of transparency in decision-making. I should mention that the institutional concerns of the prosecution, in our opinion, were detailed by Ms. Roshka when it comes to the findings in the report, and I welcome the effort in this regard. When it comes to transparency in the decision-making process, well, indeed, we have Article 21, which provides for the stages, principles of writing laws. Unfortunately, the last draft laws that have or that are already laws in force, this is a consumed matter already. So prosecution hasn't been fully involved in a debates or in consultations that will be taking place at the appropriate periods of time. We come with draft 180, 181, those 44%, less than 7 days, actually in 3 days, the first reading, and 14 days, second reading, approval of the draft laws. And on the 20th day, promulgation of it. Well, the opinion of the prosecution have been formulated. Of course, they were formulated and submitted to the responsible authorities. And what we haven't seen the summary and analysis of the proposals and objections. We don't know if they were taken into account or not, and why they were not taken into account if they weren't. You know that they have been requests to the Constitutional Court on this. There is a decision regarding the procedure, and we have not received an answer about the problems, about procedural matters, and the interpretation of law. This is still open. This question is still open. Of course, prosecution highly appreciates the efforts of the parliament, government, oriented towards reform and strengthening, institutional reform and strengthening of judiciary and prosecution. It's just that, of course, we opt for a full process in which we involve both the authorities which are presented in the draft, which will be applied later on, and it's very important to avoid any corporate interests. It's important to offer this for society and NGOs the opportunity to talk openly in an open framework, talk about the problem, so that we don't create some mechanisms which will make it more burdensome to reform the state bodies. One more matter about the legal process. I refer here to normative acts subordinated to the laws. When there are situations when you submit certain complicated documents for opinion, but with a very tight deadline, 2 days, 1 day. So we have these situations as well. I mean, and we have seen this during the years. Do we have these cases when we have to give an opinion in very, very limited time? But to be able to formulate an opinion of the institution, prosecution also requests the opinion of its colleagues from specialized prosecution, territorial prosecution offices, just to have a clear picture of the whole prosecution system, given the problem that we're facing, that colleagues are facing every day. The initiative and the efforts.
Urmează să regândim, să revizuim practicile aplicate, da? Și totuși punem accentul pe respectarea legii privind transparența în procesul decizional și a legii privind cu privire la actele normative. Pentru a exclude pe viitor și asemenea advertențe sau crearea unor percepții de desconsiderare a prevederilor legale sau a opiniilor instituțiilor vizate prin acte normative adoptate și care sunt intrate în vigoare. Vă mulțumesc și iarăși reiterăm că procuratura este deschisă de fiecare dată pentru a participa la orice dezbatere publică, inclusiv acte normative pe care noi le elaborăm, noi le plasăm permanent pe site-ul procuraturii la rubrica transparență decizională. Actualmente avem în jur de 24 de proiecte de acte normative care au fost trimise Ministerului Justiției în perioada ultimilor ani, care iarăși le puteți consulta, eventual ne puteți reflecta opiniile divergente care ar exista. Mulțumesc doamnei Bostan, întregii echipe pentru efortul realizat și vă doresc o zi bună. Mersi.
Mulțumim, domnul Vadă, pentru intervenție. Și acum aș vrea să ofer cuvântul doamnei Veronica Roșca, vicepreședinte a Comisiei Juridice, Numiri și Imunități din cadrul Parlamentului. Dar înainte de a oferi cuvântul, aș vrea să dau citire unei întrebări. Deci, întrebarea tocmai se referă la activitatea Parlamentului. Întrebarea conține și o trimitere la articolul 14 din lege, adoptarea deciziilor în regim de urgență. Eu am dat citire.
Adopting urgent decisions. I'll read panel 2.
So the
fără consultarea cetățenilor.
to argue for the need to urgently approve the law without consulting the citizens, established in line with the law without involving other stakeholders, most of 10 days by posting it at the premises at a visible space, or by posting it and can you give examples on such arguments about the need to approve urgent, which refer to the activities of the Parliament and did not refer to the COVID situation? So this was a question sent by Eugen Rybka, and this is a quite pertinent question with regard to the respect of the requirements of the law on transparency in decision-making process. And I have the honor to address this question to Ms. Veronica Roșca. Could you also please take into account this question which had been asked? So good morning, everyone. First of all, I would like to thank you for this opportunity and respectively for organizing this event with the entitled Transparency in the Decision-Making Processes, which are the expectations and the realities, respectively. So today I have this ungrateful position to represent the Legal Commission on Commission on Legal Matters and Immunities, and unfortunately, I have heard a lot of unhappiness with regard to these timelines, and And sometimes I have noted all these things, and unfortunately I will not be able to assist at the entire event. And if you could check this, and did the chairperson of our committee manage to connect? Yes, I am here. Yes, Ulisa, hello. Well, as I was saying, we were very carefully listening to all the speeches, and I have remembered the ungrateful position as a MP, where the citizens in the campaign said that they did distrust the MPs, and actually very few trust the lawmaking institution. And you have you reminded us actually once again of this position. And another status which was quite unpleasant is that usually the citizens associate Parliament with a totally corrupt institution which tries by all its legal means only to include certain privileges for the MPs. This is why I would like to let you know that in the 11th legislature, definitely out of the 219 legal initiatives, there is no amendment that would include a scheme or that would be a benefit or an advantage for any MP. And I know that in the previous legislature, there were plenary sessions which provided these benefits, or I could use a tougher term to jeopardize the security, economic, social, and legal of the country. Just as an functional ill practice, on the 3rd December, 16th of December 2020, there were cases where when laws were approved, which was subsequently declared unconstitutional. Only in several meetings of the parliament, 5 laws that were approved, which were declared unconstitutional by the Constitutional Court of the Republic of Moldova. And here I would like to quote the law on ANI that was approved on 16th of December 2020. The law on the payment obligations also approved on 16th of December and declared unconstitutional. On the 3rd of December, they voted for a law on the languages which are spoken, or there were laws on media and audiovisual services. And on the 16th of December, we have approved the law on the public pension service, and there are certain discussions and dysfunctionalities in the society. This is why I would like to ensure you that the 11th legislature, the MPs, including our legal commission, is very aware of the role which the majority faction needs to assume, and all the civil servants need to assume, which are there to ensure a legal security. So the chairperson of our commission is here, and I know that today we shall be discussing the conclusions of the Analysis Center and Corruption Prevention on the previous draft laws, which had been approved already, 169. On ANI and the manner of declaring interests and property, and the law on prosecution. Ms. Stamati, if you have time to comment on that, if we have sufficient time to get her comment on that, could you please comment? Ms. Stamati, I would like to offer the floor to you because I know your agenda is quite busy. Olesa, no, you cannot. We can now hear you well. Well, good morning. I am sorry that I cannot stay with you longer than 10 minutes. And well, actually, we are aware and we understand Well, I really don't know why my sound is so poor. Can you hear me?
Yeah.
Well, yeah, it is a bit better now. Yeah, it is a bit better now. Yep, yep. There were some moments when we couldn't hear you at all, but now, well, I cannot hear you, unfortunately, and I cannot understand. Well, yeah, okay, we go on. So we understand really well the need for respecting on ensuring transparency and the laws which are promoted, approved by the Parliament of the Republic of Moldova. And we are trying, every time we're trying to ensure the minimum, at least the minimum necessary. Indeed, there are situations when we need to rush into approving certain laws. And this rush is justified, including by the fact that the citizens that Veronica Roșca has mentioned in her speech are waiting for changes in the society, especially as regards the reform of the judiciary and of the justice and fight against corruption. Changes which our citizens have been waiting for years. And in this regard, and they expect this from those whom they have entrusted the power. And we would like to ensure the balance, to strike a balance in implementing the recommendations of the Parliament of the civil society. Yes, the law on the prosecution service had been promoted faster than other draft laws, but if we look at the law on amending the integrity legislation, you will see that although the project had been registered on the 4th of August 2021, it had been approved in the final reading on October 8th, 2021. So there had been 2 months between the registration of the project and the approval in the final reading. And subsequently, we have received both opinions and notifications from the civil society and so on. So they have been taken into account. We have had public consultations. We have discussed with all those that had time and wanted to participate in the public consultations. And we have collected proposals from the participants. And some of the proposals had been reflected in the final version of the draft law approved in the second reading. Now now the MPs have one of the drafts which had been promoted by the legal committee. It is the amnesty law. We have consultations announced already for Monday. Sometimes we manage to have the consultations before the first reading. Sometimes we don't manage to make them before the first reading, and then we organize them between the first and the second reading. And then if we receive pertinent proposals or proposals which go which resonate with the concept of the project, they are integrated as amendments to the project, as amendments proposed by colleagues and MPs, and the proposal accepted by the legal commission between the first and the second reading. So I think that the minimum possible, and often we try to make more than the minimum, as regards transparency and the public consultation of the drafts that we promote at the Parliament level. So that would be on our side. If there are questions, I have still 5 minutes, otherwise then I will have to connect to another meeting. Ms. Stamati, there is a question which we have received from a participant to this event. I have read this question, but I would like to read it again. The argumentation of the need to pass a decision urgently without consulting the citizens needs to be brought to the knowledge of the public 10 days. The longest in the term would be 10 days to the public opinion. I mean, every time you pass a law urgently, you need to to argue that, to give arguments for that. And Mr. Ripka was asking if you could give us examples of such argumentation on the need of passing urgent decisions, examples which refer to the activities of the parliament and do not refer to COVID. So it's not COVID-related decisions. So the need to pass urgent decisions. So if you have noticed in the parliamentary practice of the current legislature, there were no situations when draft laws had been urgently passed in the first and second reading in the same meeting, just the draft laws to ratify certain international conventions when the opposition had been asked in the plenary session of the parliament if they agreed to support the law, and then we voted for the draft laws at the same session. Usually there are at least 10 days, at least 2 weeks between the first and the second reading. And that is a timeline when everyone is invited to make proposals and suggestions to improve this draft. And each proposal is revised by the Commission. Therefore, I don't think it was the case to which Mr. Ripka referred. If the Parliament needs to justify the need to urgently pass decisions, because there were quite a few, or there were no decisions. Ms. Tamati, if I may help you, Ion Krange, we had a case with a budget law, and the government made a request to the Parliament asking us to revise the budget law in the second reading a bit sooner, a bit faster than those 10 days, which are reserved for the MPs for the second reading. And upon the request of the Permanent or Standing Bureau, the Parliament accepted that. And we have looked at this law a few days before than those 10 days in order to compensate the debts relating to the gas cost increases. So this is to explain such interventions. Otherwise, we didn't have such requests. Thank you, Mr. Krang. Indeed, this happened recently, last week. Well, I guess that in this situation, there was also an argument, but given the statistics presented by Mr. Purvan, the most of draft laws represent initiatives of the MPs, and even under these conditions, over 44% had been passed in a timeline of less than 7 days. In case of these draft laws, has there been an argument behind, given the urgency? The urgency which actually implies that the provisions of the law on decision-making transparency have not been observed. Well, we can't say they have not been observed. No, this respect had been mimed. How can you say that? As long as the draft law is posted on the website, it is subject to public consultation. It is approved in the first reading, and in between the readings, there is at least 10 days time span. So we cannot speak of, this is about more rapid approval, but not miming it, and moreover urgent approval. It's not urgent approval.
Actele legislative de pe rolul Parlamentului au fost adoptate
and they have been approved in up to 7 days, or the law on decision-making transparency provides for a minimum term of 10 days. So this is an issue. You mean 7 days from the moment of registration of the draft? But don't you also consider the timeline between the first and the second reading, which is always 10 days? No, this is 7 days. So 7 days between the registration and the first reading, approval in the first reading, but there's also 10 more days between the readings. Well, in any case, the issue with the respect of these timelines, which are provided for by the transparency of the decision-making process, it is there. Ms. Bostan, if I may, a little comment, and then I would have to disconnect. So this thing with the timeline between the or before the first reading also has a very practical example. As soon as the draft is registered, when there are proposals from the civil society or other authorities, you can no longer make amendments to the project, to the draft. I mean, you can make changes to the draft between the first and the second reading. And then all the proposals that are received in this timeline before the first reading, they are analyzed and considered between the first and the second reading. So practically, you need to consider the timeline between the registration and the first reading is not so, it's not so important, or I mean, it's not of big importance, rather than the proposals made between the readings, which can be accepted or analyzed from the perspective of the changes to this draft law between the first and the second reading. That was my only comment. Now I unfortunately really need to disconnect. Thank you very much for this event, and I would like to wish you a lot of success in your activities. Thank you very much, Mr. Mati, for this clarification. We will definitely take it into account when we shall monitor the effective application of the law on decision-making transparency. Ms. Bostan, if I may. Yes, for us, it was really important to have Ms. Stamati take the floor. I'd like to inform you that I will try to stay, and I think that Mr. Pervan had a question. I am here. I could take questions whenever you would like to ask them. So if there are questions about the transparency in the decision-making process, I have seen a hand raised, and I want to be fair, and I will try to stay until the end. So, dear colleagues, if you have questions to our colleagues in the parliament, please ask them. Vioriel. No, I just wanted to make a clarification and comment. No, we don't have any intention to, be a boxing bag, and we just want to have these laws which would be better and of higher quality. And I would like to encourage you to take advantage of our recommendations, and both the authorities and the civil society stakeholders. But I wanted to make a clarification as regards the draft law 169, because again, if we look at these aspects, we have the legal framework. We have the law number 100 from 2017, which expressly reads that when a draft, after consultation and after notifications, new concepts are entered, or the text or the wording changes at 30%, it has to be subject again to public consultations. This has not happened. And our remark on our side was why we hadn't followed the consultations on already essentially amended draft, and why supplementary consultations have not been organized. Well, thank you very much. I would like to offer the floor to Mariana Kalugin. Mariana has raised her hand for quite some time, so I hope you can hear me. Good morning. So first of all, I would like to congratulate our colleagues for the survey that you have made. Indeed, these are statistic data which actually do not differ from what we have seen in the previous legislatures, because we have I don't know, some 10 experience of 10 years of 10 years of monitoring. Oh, it's 16 actually, not more than 10 is 16. Yeah, and you know what it means when the MPs, mainly MPs in the legal initiatives, and this usually happens in a lawmaking body which actually tries um, to reflect on the conditions of the decision-making transparency. And why? This is because for MPs it is much easier and much, well, it would be much easier to get a draft law approved if it comes from an MP, and then you don't have to go through this notification process from all sorts of stakeholders, and then you just need the notification from the government. And there is a newer experience when we had this case studies that you have quoted now as examples. As far as I remember, all these documents have been passed in the first reading without the notification from the government, when there was no anti-corruption review, and also there was no notification of the legal department of the Secretariat of the Parliament. So these draft laws were approved without having a complete file, as it is requested by the regulation of the Parliament. If it's about 70 draft laws out of 100 and something put forward by the MPs, now you can imagine which was the interest and the rush to approve these draft laws. And of course, will be speaking of citizens, those that request this or are looking for these reforms and waiting for these reforms. But I think that the citizens could have waited for 14 more days between the registration of the draft law and the first reading of those draft laws on ANI, in particularly that we speak of this, that this draft law has not achieved anything, even if it can be challenged now, and even the protocol on the initiation of the control can be challenged. It's not the citizen that could do that, and this is just a simple example. And what should alarm us indeed was that this rush was justified through the desire of the citizens, through different commitments which existed, including in the part with the Memorandum of Understanding with the European Union. But if we were to look at the text of the memorandum, in its part on ANI, it focused only on 3 main ideas, which could make a project only by focusing on these ideas. And if I remember well, it was about making ANI more efficient by extending control over related persons, the possibility to offer the right to the inspectors to ask for the market value for assets. And just like you, the CAPC, we also had comments and objections to these provisions, and the memorandum had provisions which gave the possibility to the Republic of Moldova to renegotiate certain conditions, and that was this was also when the government changed. And for me, that would have been okay. The worst thing is that when we talk of important things as regards important anti-corruption things, very little attention was paid. And the meeting of the states against corruption, this group where the report of the Republic of Moldova will be reviewed.
și 4 recomandări neimplementate. 2 dintre acestea țin tocmai de
And we
deputați.
have 4 recommendations which were not implemented, and 2 of them refer to the MPs, and they as refers to the lifting of the immunity of the MPs. It's still confusing, and it is perceived as a weapon to get revenge of the opponents. And as regards the prosecution service, because another draft law was on the prosecution service, that was about something else, on which to which the MPs did not pay attention, so that that the prosecution would be subordinated to the Supreme Council of Prosecutors, not the Prosecutor General, and to make the disciplinary procedures more efficient. And it is really interesting whether the report that will be heard this year, this week, Moldova would probably be non-compliant to the Greco.
Foarte clar care și-au asumat acest lucru. Deci e vorba de majoritatea parlamentară, e vorba de Partidul Acțiune Solidaritate. Iată de ce, stimați cetățeni, inclusiv subiecti ai declarării, care până la 31 martie,
Before 31st of March, you would need to submit declarations and other conditions that you've done so far. And you will not be in the real impossibility to do it. If you cannot do it, then the responsibility is on PAS, is on the Solidarity and Action Party. So that is, in a nutshell, what I wanted to tell you. Just want to draw your attention to the fact that urgently you will justify the drafts that are justified by cases, by such a situation, and none of the drafts that we've discussed today never did that. So one more thing, since we had different practices, the interests can be very different. You could have very narrow interests, private ones, but there could be group interests, party interests, and interests to subordinate the authorities. Now, I cannot imagine to what extent a citizen wins from the lack of a competition in the appointment of the director of NAC. Thank you so much. Thank you very much for this opinions that came from you. Ms. Roshka referred to the intentions of the MPs when they promote draft laws. Now, if I remember well, the sessions of the parliament from last year, I remember the MPs, they were talking precisely about the public interest when they promote the laws that the current MPs criticize. You know, MPs, politicians would always, even when they do the worst thing in the world, they would always, they will never, you know, take into account the public interest. Look, we've been looking at the process of adopting laws in the parliament. The MPs were always talking about public interest. We've looked at the notes to the draft laws. With all that behind this public interest, declared one, you had what? They stole billions and they've done very, very bad things. And the only way not to allow such violations is to respect the law. And of course, we, as representatives of
NGOs, and as citizens of this country, we will demand, we will ask that the law is effectively applied, and we will be the guardians of the transparency in this decision-making process. Before giving the floor to my colleagues, maybe to just summarize, I'd like to give the floor to Veronica Roșca, if she has anything to say about what Ms. Kalugin stated. I'm listening and I'm putting down notes, but I don't intend to offer some excuses or justifications. Because look, when they said that PAS committed, we are aware of the risks and political costs and the political exposure. It is very hard in Moldova to be called PEP or a politically exposed person, politically affiliated person. So I was saying that in 30 years in this country, one tried to transform political power and financial power, and that actually really led to put the parliament into the lowest confidence bracket on behalf of citizens. And now it is very hard to rebuild this lost confidence. You need, look, the culture of transparency must be a fundamental element in all the activities and actions. And I would be happy to tell you that in this 11th parliament, even the voting procedure or the numbering of votes, tabulation of votes has changed. And there were situations in the previous parliament to recount, because they would count exactly as they needed for the second reading. Now, because we have it digitized, because we included the human factor when you tabulate and count the votes, well, this is a very important step, because they've installed all of this in the parliament. It's included in the parliament, but they didn't do anything. So I just need you to know that what counts for us are the opinions of the civil society. Maybe I'm in a position now, but I want a vibrant SEO, civil society, strong civil society, because the key partner of the government are citizens, and the civil society and others, they are, involved in this process. First and foremost, to make a transparent decision-making process, which is closer to the citizen. So, look, all of the comments, all the criticism is not upsetting us. To the contrary, they must help us to transform Parliament into a credible, genuine institution, and which should ensure the legal security, legal safety. That's all I wanted to say. Thank you. Thank you, Ms. Roșca, for this words. Look, this is this would feed optimism, instill optimism in all of us. But I should say that the electronic vote is a positive development in the current parliament. This is a very positive development. Let me give the floor to Eugen Rybka. He has his hand risen. Hi, I hope you can hear me well. It's about the law on the transparency of decision-making. This is a law which must be respected in Parliament, which is a pillar of experience, an example for all other authorities. Indeed, this law in Article 14 that I quoted in the chat allows for the adoption of some decisions in an urgent manner. I was interested in the examples of such practices. So an example was offered by Mr. Kranger. I still believe that these exceptions have the rightful place. In practice, these exceptions must be promoted when one should, but we also should create good best practice when it comes to the reasoning and application of this Article 14. We need examples of some reasonings of exceptions provided by the law on decision-making transparency. And I think here the Parliament has an important role when it comes to other authorities. Thank you. Thank you. Natalia Roșca, do you want to say something? Just a couple of things, and that's my last intervention. Regarding the transparency of decision-making, Article 14 that we talked about now, the Law 100 on legal norms regulates a certain process of stages and consistency of the stages. Public consultations that are being carried out in the Parliament after the approval on the first reading, they are not fit. They don't fit with in Law 100 because you have the norm which says that after the first reading, the changes must be of non-conceptual matter. They should change the logic and the essence of the draft. I guess, from what I've seen, I've noticed that there is a trend to interpret that Law 100 is only for regulatory processes for authorities and the government, and for drafts which come from the government, and less so for the legal procedure of MP's initiative. I think we should mention, we should regulate, we should specify, we should fill with procedures which should be very clear for MPs that when you do public consultations, how many public consultations there should be, where do you reflect all of these opinions that come as part of public consultations, or because from my experience in the ministry, it was a lot of blaming from, say, Chancery if the table of reconciliation was not published on the webpage of the ministry. It was very severe, and those who gave the opinions, they should clearly see whether they were accepted or not, and if they're not, then why they aren't accepted. And we have it and we make it public, but they make public the reconciliation tables that are prepared by the line commissions when it's about amendments that come from the MP, and less so when it comes to other opinions that are offered. Now, Article 14, when it talks about the emergency procedure, it doesn't say that one only means the adoption in the same plenary in the first and second reading. Well, it talks about violating the provisions of current law. The current law talks about all the stages mentioned by Ms. Bostan at the beginning of this presentation, at the beginning of this event. And when we have the adoption of a draft law in the first reading after the 3 days, as Ms. Kaluga was saying, without the opinion of the government, without the anti-corruption assessment, I think it's not the best practice that exists today. Mr. Roșca was talking about the meeting where they have approved laws in 2020, problematic laws, many of them adopted, actually declared non-constitutional, fully or partially. Well, this practice has been in place, unfortunately. Of course, I know how they voted laws in other parliaments 2 or 3 parliaments ago. Maybe someone doesn't remember, but I remember the last session of the parliament in the winter and summer sessions, 31st July and 30 and 29 December. Usually they vote massively until 12 o'clock in the PM, mass voting. So that is there, and there has been a practice like this. The fact that we today are saying it time and again, or this appears as criticism to this parliament, it shouldn't be upsetting to them. They should understand that we have claims, and we have the right for claims when we support certain things and when we supported programs that talk about respecting the law and about a rule of law country. We'll never have a rule of law country if we keep ignoring the law on decision-making transparency or the law on normative acts. Look, these are normative acts that are key principles. We want to have a specific norm, we apply principles of law. Exactly the same about these two documents about transparency. We have, because I talked about the law on prosecution, Mr. Obada, when prosecution today is supporting something, then you have a label on you and you don't want prosecution to support you, regardless of what you're saying. But the truth is, and when we examined these drafts, these were not schemes, but these are genuine laws. Because when you talk about ad hoc committees out of 5 members, but which can be functional with 3 members, with only 3 members, well, I don't know what safety, what standards are we talking about here? And when they regulated this, well, the intention was to really avoid corporatization in prosecution. And then the prosecutors, if they would be more disciplined, they could promote their sense of cooperation. So after they adopted the new law on prosecution, prosecutors did not understand what is their power as entities in the prosecution body, and what is the independence of the prosecutor, and what are the opportunities offered by these norms. Probably we should, some time has to pass when the subordination is out of the thinking of prosecutors, because unfortunately it's there. But so to ensure that decision-making transparency, because we have a lot of problems with transparency and ensuring the stages in the parliament. And I'm not talking about procedures of registration and adoption in the first and second reading, but I'm talking about respecting the stage of public consultation, finalizing the draft, and aligning the opinions that come. That is all from me. Thank you, Natalia, for this words. I didn't give the floor to Montano for anti-corruption prosecution. Mr. Montano, are you with us? No. Viorel Pervan? I don't know if Ion Krang is there.
Eu mă gândeam să merg conform agendei, după care să cuvânt liber tuturor de completare eventual.
Atunci doar o remarcă
Just
ca și concluzii din partea.
Some conclusions from me. We're at the end of this agenda. Transparency is not an easy thing. It requires effort. You have to have the intention to be transparent, and then an effort must be made. Sometimes because of that, they give up on transparency because there are certain procedures, some more bureaucratic, some take a long time, But the purpose of this procedure to ensure all parties were involved, parties were heard. They've discussed risks, they eliminated them, and then they have a normative act, a law, which is good, high quality, which can be applied. And only when the authorities, and in this Parliament, understands that transparency is important for them. To be the transparency will increase the level of confidence and will reduce the doubts or the issues or questions that the public could have, representatives of the civil society. We urge on you to be transparent and to comply with legal requirements and to see together how that will improve the legal framework and culture and the rule of law. Thank you. Thank you so much. Now I give the floor to my colleague, Lilia Ionita. Yes, hopefully you can hear me. Hi, everyone. I will try to summarize what has been mentioned by most of the participants at this event. Of course, the topic of decision-making transparency is a topic of major interest for the whole society, civil society, which made some declarations and public calls starting from August, when they started the first meetings of the parliament, sessions of the parliament, and we've encouraged the parliamentarians to draw the attention and to comply with all the conditions regarding decision-making transparency, because actually decision-making transparency is that bridge of confidence between decision makers and interested and stakeholders. Any deviation in the construction and maintenance of this bridge of confidence would erode it, and at a certain point in time, this bridge will fall. Now, what we talked about today. Look, my colleagues presented two case studies which showed you how you should not do things when it regards transparency, because both when you talk about changes to the law on prosecution and law on organization and functioning of the integrity agency, I mean, there have been certain slippages, and representatives of the parliament say that apparently they've respected these requirements. In my personal view, well, I think that there was a disaster, and when they said that the opinions are examined in the parliament, as was mentioned by Galina, we have a very good experience when it comes to monitoring the decision-making processes. And what was proved by our experience is that the weirdest things happen between reading 1 and reading 2. We have the example of the law on declaration of interests and public and incomes. Of course, we mentioned, we commented, and we made the recommendations to the draft. But then we looked at a draft of the law which was totally different compared to the one that was offered initially for comments. Well, what is the whole purpose of it? If it's been reading 1 and reading 2, it has been changed dramatically, this draft law. I mean, you had new norms that have no mechanism of application, and there is no explanation. We understand that the citizens wait that the order is done in this, but I think that the order cannot be done if you violate other rules. So the transparency of decisions, which must be respected by the parliament, is important, including when it comes to the messages that they transmit. When the parliament doesn't respect these requirements, its own standards that they've imposed through the norms of the law, look, it gives the signal to society that, well, you can do it, you can omit certain stages of the decision-making process. And if Parliament violates these norms, then for sure other authorities that are decision makers when it comes to this country, they will do exactly the same. They will apply the same procedure. Public consultations are important from the point of view of having some ideas in place. So the best or the most unique solutions can come from the opponents of these reforms, because you can change things to the better at the stage when the draft law is still being debated publicly. And then you have to listen carefully to all the participants, which is part of these public consultations. We know very well that no one holds the ultimate truth. The truth, or at least the general principles, they can be established as part of some comprehensive large discussions. And one more thing here, when they've allowed certain derogations, some distancing from these principles and rules of transparency, would have loved to be told why, they've departed from this. We haven't had this one, and we haven't had any clear explanation. Of course, we can, deduct this of what would be the reason in case of the law on National Integrity Agency, but it would have been nice, it would have been elegant if this justification came from the decision makers. So that is all I wanted to mention as a result of these discussions. Thank you. Thank you so much for this words. Let me give the floor to Ion Kranga. Thank you, Galina. I will start. I think that transparency during the years has evolved quite well. It has been institutionalized, it has been regulated, it has been consolidated. Today, we can time and again assess this transparency and to see what are its results. Now, I should tell you that transparency is a condition of legality, constitutionality, and quality. So you have three key elements when it comes to transparency. The law is not done by MPs, it is done for the citizens, and their opinion is crucial when you talk about a normative act. Well, we have different situations in the society. We have the pandemic, we have emergency situation, we have other circumstances, we have other circumstances which determine us to be prompt in a short period of time. And here we find answers in the law on transparency, which says that you can restrict it to a certain time frame, period of time. In the parliament, you have a special article of when we can make it urgent. If you look at the article 44 of the regulation of parliament, then we can notice that to start the emergency procedure, we need the request of the Prime Minister. We need that in the plenary, the Prime Minister would come and justify why this draft is required to be expedited. And then, of course, civil society is saying, well, a number of MPs initiatives which have been examined in a procedure by shortening all periods at every stage would be a problem. Probably you are right when you talk about it, because all of those called to contribute with an opinion could be in a delay. Any of the suggestions and proposals can be valuable. And here there is a problem, because after the draft law has entered into the legal procedure, it is published on the web page. Everyone has access to that information. And here we don't have any issues. The issue is when we talk about taking over the contribution of the civil society, of stakeholders that come and propose to the parliament changes, where we have the concept of cooperation with the civil society approved through parliament decision, which provides for the procedure, but also have the decision of the Constitutional Court, which says that any change to the draft is done by amendments from the MPs. Now, my question is, if MPs don't want to accept the proposal of the civil society, who promotes them further? No one. We do a reconciliation table, we list all the proposals of the civil society, and that's it. Because no one accepted them as an amendment. One of the biggest problems that exists in our legal process is working with amendments and the transparency of amendments. Because actually, besides the Commission, no one else works with amendments. And either influenced by political interest or subjective interest or other interest. I mean, you could have in the final text of the law, you could have some amendments that no one has ever seen. As you said, look at the law on the National Integrity Agency. You have their elements, institutions, and we don't know where they come from. So that is an outcome of the procedure in the second reading. Maybe you have arrears when it comes to regulatory changes in this regard. So we have to assess them with you and to see how we can ensure this quality better. Because if we don't comply with this procedure, with this quality, then we'll have the case law of the Constitutional Court that declared unconstitutional a range of laws which did not comply with certain procedures on the platform of the Parliament.
This is why we strictly respect the timeline between the first and second reading, because the law clearly says that there should be a certain timeline observed between the readings, and all the rights of the civil society and other stakeholders are until the first reading, 30 days. If we look at how long a draft law needs to be approved or reviewed from the registration till approval, we will reach the conclusion that it would take 2.5 till 3 months to review one single draft law. And when it takes us 10, 20, or 30 days, I would say that this is some sort of an emergency dealing with that. I understand that urgencies can be determined by electoral interests, political interests, and pressures put on MPs. And in our case, we have also a government, a fresh government, which had not yet managed to understand We have also a functional parliament, which has taken over a range of legal initiatives from the government, and it would be good that some draft laws would first be taken through the platform of the government and then come to the parliament. And there is also this procedure, a legal initiative of the MP. Legal initiative of the MP is another procedure. And Ms. Kalugin has mentioned this because the MP, when the MPs put forward these initiatives, they submit this draft to the NAC and the government needs to include the opinions of all the related stakeholders. The regulatory impact needs to be shown, and the analysis of the compatibility of the draft law with the EU acquis. And if the law provides only for 30 days for that, I don't think we manage that. And the consequence is the quality. All these things happen in the processes which are described today in the law, and they are legal, that are used, and these are not always used. And we, together with you and the MPs, we need to consolidate our efforts and give positive or negative assessments and the things which we need to give up on, where we need to strengthen, and what we need to do to make things done in a better quality, better standard for everyone, so that when the law is being implemented, we don't face different issues which would put everyone involved in these procedures at difficulty, so that they do not know how to implement the law. So this was, in general terms, what I wanted to mention for my speech and for the topic that you have addressed. This is quite an interesting topic, which is continuously strengthened and continuously developed, and we need to strengthen it together. Thank you. Thank you, Mr. Kreanga, for all the clarifications that you have made and for the description of the peculiarities of the process of the circulation of documentation within the Parliament. So we have approached the end of our session. I would like to sincerely thank all the representatives of the public authorities which were involved, which engaged in these discussions. Our purpose was noble: to effectively implement and see the these are of important interest of our societies, ANI and the prosecution service. And I think our main conclusion of this roundtable and our discussions is several elements. So first of all, it is really important that the laws which are already effective are respected. And as regards the lawmaking process, this is first of all about the law on normative acts and the law on transparency in decision-making process. And by respecting the consultations, the true public consultations, and by ensuring the respect of all timelines which had been set forth in the law on transparency in the decision-making process. I would like to thank everyone for your active participation at this roundtable. I would like to wish you all to stay healthy and best of luck in your professional activities. And let us wish to all of us to have as transparent authorities as possible in the decision-making process, because in such a way it will enhance the responsibility, performance, and confidence of the citizens into the public sector. Thank you very much, and I wish everybody a great day. Goodbye. Thank you.
Bună, mulțumim.